if you entered the US within the last year and you have a fear of persecution if you return to your home country, and that fear is based on your race, religion, nationality, political opinion, or membership in a particular social group, then you might have a good case for asylum in the United States. If a green card application gets denied, the applicant will most likely receive a notice to appear in immigration court, whereby the government initiates deportation proceedings, also known as removal proceedings. So if you get a notice to appear, now what? What do you do now? I regularly consult with people who have submitted their own green card application or did it through an attorney or a non-attorney, whatever the situation might be, and it recently got denied in the last few months. And now they've received a notice to appear and are in removal proceedings. And when I'm consulting with them, we are just trying to figure out, like, when is the next court date? How good is the judge that you have? Are there any jurisdictional issues? Is the court in the correct location? Can we change venue? And what strategy should we come up with? And one of the first things I say, when someone has a hearing that's pretty far out in the future, is this process might drag out more than 4 years. And if it drags out more than 4 years, you're most likely going to have more options available to you, namely prosecutorial discretion. Prosecutorial discretion is the Department of Homeland Security's ability to prioritize cases that are priorities for removal from the United States versus other cases that might be a low risk to the United States and where it's not a good use of government resources, government's limited resources, to go after those people. For example, if we're going to compare a grandmother who's been in the US for 30 years, has been filing taxes, never has a criminal history, has US citizen children, grandchildren, and is a major pillar in her community, versus some guy who just entered the United States last year illegally and committed a bunch of crimes, has no interest in filing taxes or following the law. Like, who should be the priority for removal in this case? And historically, people who recently entered were priorities for removal because it disincentivizes more people from entering illegally during that president's administration. Whereas people who've been here for a long time, have been positive contributing members of society, tend to be deprioritized, where, it's not great that they're here out of status, but given the government's limited resources, we need to pick and choose what's in the country's best interests, and we will prioritize the people who've committed crimes or who are not good for the United States versus people who've contributed and been here for a long time and have no criminal history. And this policy of prosecutorial discretion was pretty bipartisan. Like, Democratic presidents and Republican presidents both had systems for creating priorities for which immigrants should be removed from the United States and which immigrants might be eligible to just have their deportation proceedings closed out because it's not a good use of government resources to go after them. Under the Biden administration, if you had, like, for example, a US citizen spouse and you've been here for a while and no criminal history and you're a positive contributing member of society, you were probably a good candidate to have your case closed as a matter of prosecutorial discretion, where the Department of Homeland Security says, we no longer wish to continue removal proceedings after this person. We are offering dismissal of the removal proceedings. And then if the immigrant agrees, the judge will dismiss the removal proceedings. And this person is no longer being actively deported. Now, in those instances, the immigrant will oftentimes still be out of status, but they no longer have a removal proceeding and removal order like looming over their head, where they are actually at risk of getting deported from the United States. Under Trump, there is no prosecutorial discretion. Whether you entered 30 years ago and are a good member of society with people who can vouch for you, or you recently entered and committed a bunch of crimes, you are both equally deportable, and the same amount of government resources are going to go to removing each one of those people. Anyway, this is just a long-winded explanation of the history of prosecutorial discretion and how this might come back, and probably will come back if we get a Democratic president, like once Trump is out of office. assuming he's out of office in 4 years, of course. But what about people who have like a fast approaching court date? First of all, after you receive a notice to appear, your first court date is a master calendar hearing. It's not going to be the hearing that decides the outcome of your case, for most people anyway. And that assumes that you get a lawyer before it, because there have been instances where people show up to their master calendar hearing and they are unprepared, and the judge just orders them removed, and then ICE officers who are sitting in the back of the courtroom just come and detain them and escort them out. So, it is a riskier time now more than ever to attend these hearings without an attorney. But even if you attend a hearing in like a favorable jurisdiction with a really nice judge who's immigrant friendly, they're going to tell you at your first hearing, like, you need to come back with a lawyer. This is super complicated. You should not do this without a lawyer. It is theoretically possible to do it without a lawyer, but I really would not recommend that. And this whole channel is designed to help people like do their own immigration stuff where it's possible. But removal defense is not one of those things that you want to do by yourself. You're going to end up getting a removal order if you do it yourself. Okay, so let's say you have a master calendar. Your first preliminary hearing is in December 2025. And we look up that judge during a consultation, and I figure out that like this judge is scheduling final hearings pretty quickly, probably within like a year or two of this December 2025 hearing. You're going to have your final trial date where the judge is going to make a decision on your case and either approve your application for relief from removal or order you removed from the United States, which is a deportation order. What options might be available? So we're going to go through, during the consultation, we go through all of the possible options that might be available. I'll just briefly list a few options that I regularly go through, just in case, you need a place to start because you're going through this and, you need to organize your thoughts. One of the things is asylum. If you entered the US within the last year and you have a fear of persecution if you return to your home country, and that fear is based on your race, religion, nationality, political opinion, or membership in a particular social group, then you might have a good case for asylum in the United States. And if you're granted asylum, you will be on a pathway to permanent residence. 1 year after your asylum application is granted, most people will become eligible to submit an application for permanent residence. And then down the road, if you meet the other requirements, you can apply for US citizenship. So asylum is one of the first things that I screen people for. You hear a lot of stuff in the news about people getting detained at their asylum hearings. True, but also blown out of proportion. It's more likely that you'll get detained in certain courthouses. For example, 26 Federal Plaza in New York City is one of the places where the Trump administration is implementing this pilot program where they detain immigrants who show up to their hearings. And there's a couple other courthouses where this does happen, but it's not happening to most asylum applicants who are in removal proceedings throughout the United States. Another form of relief that's available to some people is something called cancellation of removal for certain non-permanent residents. The actual application is called EOIR 42B. And cancellation of removal has three main requirements. The first one is you must have been physically present in the US for at least 10 years before you receive that NTA. The second one is that you must have been a person of good character during these 10 years. No major criminal history, like some minor stuff might be okay, but no major criminal history, and positive contributions. A lot of judges like to see that you've been filing tax returns during this time. If you haven't, some judges will just say, like, be sure you file retroactively your last 10 years of tax returns before the final trial date. Depends on the judge, depends on the jurisdiction. The third requirement is the hardest one for most people to meet. To qualify for cancellation of removal, you need to demonstrate that you have a child, spouse, or parent who is a permanent resident or US citizen, and that this family member or multiple family members will suffer extreme and unusual hardships if you are removed from the United States. Extreme and unusual hardship is way more hardship than an ordinary family member would experience. For example, if you have a child who has like ADD and asthma, right? And you're gonna argue he won't be able to receive care for his ADD and asthma if I'm deported from the United States, from Mexico. The government's probably not going to buy that. Like most a lot of people have asthma and ADD. That probably isn't going to rise to the level of extreme and unusual hardship. And I don't know what the medical facilities in Mexico are, but I'm pretty sure they could handle ADD and asthma. I could be wrong on that, but I don't see that as being a strong case. Now, if you're from a different country, for example, Honduras, and your child has a developmental disability where they literally cannot live normally, that might be a strong case for cancellation of removal. And the beauty of cancellation of removal is if your application is granted, you become a permanent resident. There's no middle step like asylum where you first have to become an asylee and then apply for permanent residence. The application for cancellation of removal is actually an application for permanent residence. Another option or defense from removal that I'm going to be exploring is whether there's any argument that you're eligible for adjustment of status. You can apply for adjustment of status affirmatively with USCIS, like if you enter the US with parole or a tourist visa or something, you marry a US citizen, you apply for adjustment of status with USCIS. But let's say you make a mistake in that application, it gets denied and you're referred to immigration court, an NTA is issued and they begin to deport you. You can actually still apply for adjustment of status as a defense from removal. It is a viable defense. It costs more. You're also going to need to hire a lawyer. So like instead of this whole process costing you like $2,375 if you file it with USCIS, that's excluding the advanced parole application, it's going to cost you way more than that with immigration court. Just the green card application alone is going to cost around $3,000. That doesn't include a family petition or work permit application or an attorney to defend you. So what might have been like a $2,400-ish case with USCIS if you did it without an attorney might now turn into like a $13,000 ordeal when you're in removal proceedings. But, money issues aside, adjustment of status is a viable defense from removal. And instead of USCIS making a final decision on your I-485 green card application, the immigration judge will make that final decision depending on how the policies are at that time. Sometimes, if you clearly qualify for adjustment of status, we could apply for termination of the removal proceedings, where the prosecutor and the judge both agree that it's a waste of the court's resources for the court to be the one who makes a final decision on your green card application. Since there's no negative factors in your case, they're just going to terminate the removal proceedings so that you can file this adjustment of status application directly with USCIS. USCIS only has jurisdiction, the power to make a decision on an I-485 adjustment of status application if you are not actively in removal proceedings and you do not have an old removal order. The only exception is if your notice to appear indicates that you are an arriving alien. Arriving aliens can file their green card application with USCIS even if they have an old removal order or are actively in removal proceedings. One final thing that I want to mention for people who've made it this far into the video, which I assume is not very many people since it's getting kind of technical, we might also be able to apply for something called administrative closure. Administrative closure is kind of like we're asking the government not to terminate the removal proceedings, but to pause it for a long time because we have a strong application pending, but it's going to take a couple years. A good example would be someone who's like a year away from getting their U visa approved, which could be like a 7 to 8 year process. Someone like that might have a good application for administrative closure. Another example might be someone who has like a family petition pending in I-130. Depends on who the judge is. Might be speculative. The judge might not allow that. But currently, immigration judges still have the power to administratively close cases. During Trump's first term, when the Attorney General was Jeff Sessions, the Attorney General referred a case to himself, which apparently is something that they can do, and basically got rid of the immigration judge's ability to administratively close cases. But that was reversed when Trump left office. And administrative closure is still a tool that judges have available to them, and it might be a good option if you have some sort of case pending. The final thing that I'm just going to mention, if you have no options available, but it looks like you might have some options in the future, but it's going to be a couple years, is voluntary departure. The main benefit of voluntary departure is that you can avoid a removal order by agreeing to voluntarily leave the United States. You still have to apply for it, the judge still has to grant it, and after they grant it, you have a window, it's like 90 to 120 days, whereby you need to physically leave the United States. If the judge grants voluntary departure and you leave, there is no removal order. You should typically go to a consulate abroad and register your departure to prove that you actually left. However, if the judge grants voluntary departure and you do not leave, upon failing to leave, that voluntary departure order automatically converts into a final removal order. So keep that in mind. One other thing to mention about voluntary departure, it does not prevent you from triggering a 10-year bar. So most people who get voluntary departure and actually leave will probably end up triggering a 10-year bar because they have more than 1 year of unlawful presence in the US before they voluntarily depart. They leave, they trigger a 10-year bar, and then, if they have an option to come back through a family petition or something in the future, they will still need to apply for an unlawful presence waiver directly with the consulate. That would need to get approved for them to come back in less than 10 years. All right, guys, that brings us to the end of today's video. If you have any specific questions, or you're worried about getting an NTA, or you just got an NTA and you want to speak to an immigration lawyer about what options might be available to you, you might possibly consider hiring an attorney, or you just want to talk about strategy, you're still in like the research phase because your hearing is pretty far out in the future, you should schedule a consultation with me. My name is Pouyan Darian. There's a direct booking link for consultations in the video description below. You could also go to my website, darianlaw.com, to schedule a consultation. I'd be happy to speak to you about your case, help you create a strategy, and just give you as much value as I can during our 45-minute consultation. If you're new to my channel and you want to stay up to date on immigration changes, be sure to subscribe. I put out several videos each week, and I'll see you guys next time for another video.